Roe versus Wade is overturned, and so is the 1992 decision upholding it, Casey versus Planned Parenthood. And that is a good thing. The decisions were an embarrassment. They were a legal invention driven by ideological courts bent on finding constitutional rights that did not exist. It was judicial activism, which misled the country for nearly 50 years into believing that the court had powers it didn't and that women had constitutional rights they didn't. That was wrong. To the extent women are feeling like the rug has been pulled out from under them today, that is the fault of the Roe and the Casey courts, not of this court. Abortion is not mentioned in the Constitution. The challenge all along has been to figure out whether it is nonetheless an implicit right, as the court has reluctantly from time to time recognized implicit fundamental rights, even though they're not specifically spelled out in the Constitution. That's happened. Roe found the abortion right was such a right, rooted in an alleged constitutional right to privacy, which also is not mentioned in the Constitution. And then Casey, 20 years later, switched the rationale, presumably understanding that they were on shaky ground when dealing with the right to privacy, saying abortion rights actually derive from the 14th Amendment's Due Process Clause, which provides that no person may be deprived of life, liberty, or property without due process of law. Now, for part of our country's history, the Due Process Clause was thought to simply be about process. It guaranteed that, for example, the state could deprive someone of their liberty or even their life, but would have to afford them due process first. Then the court started recognizing something known today as substantive due process, which the late Justice Scalia and now Justice Thomas called a contradiction in terms. If it's about process, it's about affording somebody process, not new substantive rights. In any event, substantive due process liberty rights is where Casey in 1992 found the right to an abortion. The majority in Dobbs, the case decided on Friday, held this reasoning was, quote, egregiously wrong from the start. That among other things, implicit constitutional rights must be deeply rooted in our history and our tradition. That's a quote. And that abortion never was. When the 14th Amendment was adopted, 3/4 of the states had outlawed abortion at any stage of pregnancy. Okay, 3/4. Even by the time that Roe was decided in 1973, 30 states still banned abortion altogether. The notion that abortion was a right had not been recognized by any court, state or federal, until just a few years before Roe. So no, this was not a right deeply rooted in our history and our tradition. No matter to the courts in Roe and Casey, which decided they knew better. Just as the country was beginning to evolve politically on the issue of abortion, the Roe and Casey courts stepped in and short-circuited the political process. Even Ruth Bader Ginsburg later acknowledged that fact. Worse yet, the Casey court, swimming in hubris, called on both sides to, quote, end their national division by treating the court's decision as the final settlement. Really? Not surprisingly, no one listened. And the debate has raged on for some 50 years since Roe. Even now, 26 states petitioned this court to overturn Roe and Casey. Nothing has healed. No divisions have ended. Because this is a matter for the people to decide. Not 9 unelected people in robes, but the citizenry of the states. And now the matter goes back to where it ought to be, to the citizens of each and every state. Are you angry about abortion rights being stripped away in your state? March, petition, vote, exercise your rights to be heard and have your opinion taken seriously. And if you lose the fight, you may have to consider other options, like voting with your feet, just like we do when other policies convince us that our state does not represent our values anymore. This is the way it ought to work. The Supreme Court was never meant to be a kind of super legislature. It started looking more like one when the liberal belief of a, quote, living constitution took root. This concept is all over the dissent in Dobbs, which is emotional and distraught and reads very much like a policy prescription you might hear from AOC. As Justice Scalia once observed, if the Supreme Court was meant to see the rights in the Constitution as expanding based on the changing views of equality or liberty or decency, then why did we need the 19th Amendment, which afforded women the right to vote? Why didn't the High Court just rule that the Due Process Clause mandated this right? Because jurists in this country used to agree that the Constitution governed a few key things and the rest of our rights would be determined by the people. The people in 1920 felt that women's suffrage was so important, it deserved better than a state-by-state evaluation. It deserved to be a part of the Constitution. That is why they passed a constitutional amendment. And they could do the same now on abortion if they could convince the country to support it, which, by the way, they can't. The support for it is not that wide. That's why it's going to remain a state-by-state issue. That's how a federalist system works. Accountability among our state representatives who make policy decisions every day and who answer to us at the ballot box. Not some sweeping grant of power to 9 judges to tell us what's decent in modern day America. One last point. The dissent in Dobbs is not wrong that other decisions based on the alleged privacy right mentioned in Roe or substantive due process liberty cited by Casey do not necessarily pass the test outlined by the majority. They're not wrong about that. Was contraception, homosexual sodomy, gay marriage, or interracial marriage, quote, deeply rooted in our country's history and tradition, the test to which they subjected the abortion right? No. So are those rights going away, as the dissent and some liberal pundits now claim? Well, the majority explicitly and repeatedly says absolutely not. And that assurance is worth a lot legally. You just wait to see when somebody tries to challenge one of those cases, that majority language coming back to haunt them. They probably won't even accept those cases, but if they were to, that language in the majority opinion will come back to haunt anybody trying to challenge the right to contraception, etc. Nonetheless, the dissent and liberal pundits remain skeptical. In my view, the majority should be believed for 2 reasons. One, as the court points out, abortion is in a class of 1. None of these other rights involved such a grave clash of interests: an unborn child's right to life against a mother's right to control her own body. And where cases can be easily distinguished from one another, the tossing of one is far less likely to lead to the tossing of the other. Second, each of these decisions is entitled to its own stare decisis, or respect, as a precedent of the High Court. The court, in applying that stare decisis test to Roe and Casey, did not find them worthy of deference for a whole host of reasons. But the majority points out that each of these other decisions on contraception, interracial marriage, gay marriage, and so on would get its own stare decisis analysis, and the factors that led to the rejection of Roe and Casey, including how unworkable they proved to be, the line of viability, the 3-trimester system that Roe imposed based on nothing, and so on, how egregiously baseless they were from the start, and the extent to which the public has relied on them, would lead to very different conclusions in these other cases involving rights to contraception, interracial unions, and gay marriage. All right, so that's fear-mongering by the people who just don't like today's decision. In sum, there is every reason to believe that these legal precedents will remain safe, as the court has all but guaranteed as much, and there is no legal will to overrule them, save for basically Justice Thomas, who admits in his concurrence that he doesn't really believe in substantive due process rights and would leave all of this to the legislatures. Moreover, unlike abortion rights, there's nothing about these rights to suggest that they've been unworkable or that they even remain genuinely controversial. Who's out there running around opposing interracial marriage, right? Or contraception? Even gay marriage has now got the majority support in this country. Bottom line, Roe and Casey needed to go. As the majority found, they usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Now the fight will play out where it should, in the political arena. And I have no doubt that both sides are well suited for the battle. Are the high fuel costs putting a damper on your summer vacation plans? From higher prices at the pump to a jump in airfare, it is getting more expensive to get away for a week. But what if you could soak up those vacation vibes year-round without even having to leave your property? Get a Michael Phelps swim spa by Master Spas and you can do it. Whether you want to stay close to home this summer or just want to extend your break, a Michael Phelps swim spa by Master Spas can transform your backyard into an oasis. It combines the benefits of a pool with the therapy of a hot tub. This is going to reinvent your family time. You will love it. Your family will love it. Your friends will love it too. Michael Phelps swim spas by Master Spas come in a variety of sizes to complement virtually any yard, even if it's a small backyard. And since it's heated, you can use it year-round in any climate. Michael Phelps swim spas are 100% made in the USA by Master Spas. That's the world's largest swim spa manufacturer. Their success is for a reason. Go to masterspas.com, put in the promo code MK to save $1,000 on one of those Michael Phelps swim spas or $500 on a Master Spas hot tub. That's masterspas.com, promo code MK. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.